So you're under contract to sell your house and you change your mind. It could be because you've had a life circumstance arise. Maybe you're ill, maybe your spouse is ill, maybe your job transfer fell through, maybe your promotion fell through, whatever. Maybe you got an offer that you think is better. You've decided to change your mind. What happens? My name is Sharon Smoot. I'm a realtor and a residential real estate closing attorney in the metro Atlanta area, and I am going to answer that question. So, the Georgia Purchase and Sale Agreement specifically sets forth what happens if you, as the seller, default on the deal. It also sets forth what happens if the buyer defaults. But today we're focusing on seller default and what remedies are available to a buyer when a seller defaults on the contract. So I am going to do a quick screen share so that we can take a look at the relevant provision of the contract. So the relevant provision of the January 1st, 2026 contract amendment is, or contract revision or update, is paragraph C2B, C2B right here. And what this provision says is that in the event this agreement fails to close due to the default of seller, buyer may either one, seek the specific performance of this agreement, or two, terminate this agreement upon notice to seller and holder. And the holder is the entity holding the earnest money. That's usually the buyer's broker, the seller's broker, or the closing attorney. In which case, all earnest money deposits and other payments buyer has paid towards the purchase of the property shall be returned to buyer following the procedures set forth elsewhere herein, and buyer may pursue any other remedy at law. So that's a whole lot to consider. So let's break it down. The first option that the buyer has is to seek specific performance of the agreement. What is specific performance? Specific performance is an order from the court mandating that you, as the seller, sell the property to the buyer pursuant to the terms of the purchase and sale agreement that the two of you have signed. If the buyer sues you for specific performance, they can also ask the court to order you to pay their attorney's fees and court costs. Simple as that. They can sue you. The court orders you to sell them the property. Court may also order you to pay their attorney's fees and court costs. The second option that is available to the buyer if you default on the contract is to terminate the agreement upon notice to the seller and holder. I already went over all that with you, so I'm not going to read it again. Underline that part as well. And so what does that mean? You're going to have to give them the earnest money back. So, and there's a procedure set forth in the contract for that to happen. And they have the option of going into court and suing you for all remedies available at law. So it's probably going to be a breach of contract lawsuit where they're asking for money damages. Those money damages can be actual damages, which is the actual loss that they suffered, the monetary loss that they suffered as a result of your breach of the contract, and punitive damages, which is punishment. It is meant to deter you from engaging in the same type of behavior at some point in the future. So when we talk about the actual damages, that can be the cost to the buyer to secure temporary housing while they're looking for another house to purchase. It could be the additional cost that they suffer because maybe interest rates have gone up. It could be the cost for them to put their belongings in storage because their temporary housing, it could be a hotel or a small apartment, doesn't have enough space for all of their furniture and other belongings. Now, if you are ordered to pay court costs and attorney's fees, that is just an added expense for you. So it's really important that if you're considering defaulting on the contract, that you take all of this into consideration. The other important consideration is that not only could you be facing legal action from the buyer, you could also be facing legal action from your broker, the listing broker, as well as the buyer's broker for their compensation, also known as commission. So there is a whole lot that goes into terminating into the decision to terminate a contract. And I don't want you to think that, oh, it's just the earnest money. It's $3,000. It's $5,000. It wasn't mine to begin with. They can have that back, because you could still be facing legal action. If you're thinking about terminating a contract, think twice, seek legal guidance from an attorney, seek guidance from your real estate agent, just to make sure you are clear on what you may be facing if you ultimately decide to terminate that contract.